Ready, start. Besides it, it could be seen that even in the interim order dated 26/3/2021 was passed by the DRT, the following has been stated. Learned counsel for the respondent bank submitted that the property is sold on the scheduled date of auction and the sale certificate is also issued. However, the sales certificate is not registered as of now. The applicant also paid substantial amount of dues of about 50% of the amount claimed. The applicant having paid a substantial amount of about 50% of the claim amount, this tribunal is of the considered view that a status quo order is required to be passed in the interest of justice. Hence, there shall be an order of status quo as of today. Meanwhile, the applicant directed to initiate steps to impede the auction purchaser in this case. Therefore, had the petitioner agreed for the same and remitted rupees 2 crore 88 lakh in the month of March 2021, the same would have been brought to the notice of the DRT also, and an order of status quo not to register the sale certificate would not have been granted. Therefore, when the borrower for some reasons did not repay the loan promptly, but however manages to pay the entire amount as claimed by the respondent bank, even at the last minute, the same cannot be rejected on technical reasons, as the very purpose of the law of mortgage is to create security for the loan and not to result in the ownership of the property being transferred. While we overrule the objections raised on behalf of the respondents, we hold that the auction purchasers will be entitled for the return of the entire sum of rupees 1 crore 25 lakh 60,000 paid by them, and they will also be entitled to interest at the rate of 9% per annum from the date of remitting the amount till the date of repayment. It goes without saying that it is only the writ petitioners/borrowers who have to make good the said interest amount. On account of lack of infrastructure and manpower, the regular civil courts were not in a position to cope up with the speed in the adjudication of recovery cases. In the light of recommendations of the Tiwari Committee, the special tribunals came to be set up under the provisions of the RDBFI Act referred to above for the recovery of huge accumulated NPA of the bank loans. These committees in their reports observed that 1 out of every 5 borrower was a defaulter, and that due to the long and tedious process of existing framework of law and the overburdening of existing forums, including the specialized tribunals under the 1993 Act, any attempt of recovery with the assistance of court/tribunal often rendered the secured asset nearly worthless due to the long delays. In this background, the committees thus proposed new laws for securitization in order to permit banks and financial institutions to hold securities and sell them in a timely manner without the involvement of the courts.